reality that the officer did not have the right of way and hit him. The guy has to wait until traffic clears.
As he was making that left-hand turn, he completely blocked my lane, but there just wasn't enough time. I didn't have enough space, and he still ended up hitting me.
There was no signal making the motorcycle stop. It doesn't appear the motorcycle did anything illegal. His lights were not flashing. Officer did not have the right of way. There is no law that says that if there's a police officer or law enforcement automobile, that they have the right of way on the road. If they're in the event of a pursuit and the lights are flashing, then you have to yield to him. So while the ambiguous nature of these new running lights in HCSO, because it is confusing the heck out of everybody, is just one additional reason why I think HCSO is going to be liable. But here's the hidden truth of all of this, and where it's going to be a problem is that sovereign immunity for Hillsborough County is going to attach. Those are horrific injuries this gentleman suffered. He may be facing the actual loss of his leg, and at the end of the day, Hillsborough County is going to get away with only a $200,000 or at worst $300,000 in terms of damages. The state of Florida, because it's a governmental agency, caps the damages this motorcyclist is going to be able to recover. It's not going to come anywhere near the medical, the pain and suffering, or the damages this guy's going to face. I would look for HCSO to tender those $200,000. Yes, they have a horrific new policy and procedure with these running lights.
If you see these, you don't need to stop. Just keep driving safely. Now that you know this, share this with a friend so they can know what to do when they see the lights.
But just as importantly, did not have the right of way and hit him. Who cares about the lights? There's enough evidence to say he should not have gone. Well, here's the other thing. If HCSO wanted to get ugly, thinking as a defense attorney in this scenario, they are going to try to make an argument of what's called comparative fault. The insurance company is going to say, as that motorcyclist was driving, why did he A, not yield? Did he not see the car in front of him stopping? Did he try to go around and leave his lane and go around the vehicle? Keep in mind, Florida's new terrible law regarding comparative fault says that if they can prove that this motorcyclist was 51% at fault, he gets nothing. So as a defense attorney, even though it's horrific injuries, it's a terrible scenario, HCSO with the most ridiculous new policy of these running lights confusing everybody, the defense attorneys and the insurance companies won't care. They'll try to put some blame if they go the distance of the motorcyclist. There's going to be more to the story. Ultimately, your heart wants to believe that HCSO will tender their limits immediately, $200,000 in their sovereign immunity, and say, hey, we're going to walk away from a cap. But having done this for the last 20 years, you move forward with the lawsuit, HCSO says, hey, no problem, we're going to blame you. We're going to try to put comparative fault on you. We're going to take you the distance because we basically have nothing to lose. Our worst day in court's $200,000. Your worst day in court is you take the loss and you get nothing.